Welcome to another episode of the CarryTrainer Higher Line podcast.
Hey folks, attorney Andrew Branca here from Law of Self-Defense. You're about to watch the talk I gave at CarryTrainer's recent S12 training event, and I certainly hope you find it informative and entertaining. Now, as part of that talk, I shared with the S12 attendees present our strategy for making themselves hard to convict if they're ever compelled to use force in defense of themselves, their family, or their property, and how they can accomplish this, making themselves hard to convict, for literally pennies a day. Although this opportunity was originally intended only for the S12 attendees present for the talk, after discussion, Mickey and I have decided to extend this opportunity to the CarryTrainer community generally. This means you. So be sure to stay to the end of this video to learn how you too can make yourself hard to convict. All right, folks, thank you. Thank you all for your attention. I know it's been a long day. I'm going to try to move through this as expeditiously as possible. I talk fast anyway. I'm originally from New York. This is, of course, being recorded, so if you missed something in what I'm saying today, I'm sure it'll be on the CarryTrainer website. I'm going to try to save about 20 minutes from this talk from last year by taking all the cursing out of it. So last year, the poor guys had to beep out all the cursing. It was like one 60-minute long beep was the entire presentation. But hopefully I can provide you with some insight in how the legal system really works, how it really deals with use of force cases. By use of force, I mean defense of yourself, defense of other innocent people, defense of your property, kind of pull back the curtain to give you a realistic view of how those decisions are made, what the risks are, and the risks are substantially higher than probably most of you understand. I know most of you probably have concealed carry permits. You've taken a course for that. There was a legal portion in the course. Folks, virtually everything you've ever heard about use of force law is wrong. It's wrong, or it's misunderstood or mischaracterized. Even most lawyers, my 3 years of law school, we spent 5 minutes talking about self-defense law. Most lawyers don't know this stuff. Most police know a lot more than lawyers, but unfortunately what the cops are taught is not intended to protect that officer from criminal liability. It's intended to protect his department from civil liability. So they're not really taught what they need to be taught either. So there's a lot of bad information out there. Our mission at Law of Self-Defense is to provide education, information, all in plain English on use of force law, as well as our actual legal services, which are a legal consulting service. So I'll talk about all that, talk about all the insight, and then at the end, we've done something new this year for S12. We've put together a bundle of all our Law of Self-Defense products and services for you guys to consider at the greatest discount we've ever done before, just because this is S12. So I'll share all that with you as well. So why me? Attorney Andrew Branca, Law of Self-Defense. To my knowledge, I'm the only attorney in the United States that has an exclusive focus on use of force law. I don't have a generalized criminal defense practice. I don't do DWIs. I don't do shoplifting. You only call me if you're charged with a use of force crime. Murder, manslaughter, aggravated assault, aggravated battery with a deadly weapon. We do misdemeanor stuff too, but traditionally we've been too expensive for people to want to pay us for stuff like brandishing. But that's the area that we cover. Toot my horn here a little bit. I'm a court-certified expert. I teach at the FBI Academy in Quantico. The U.S. Marshal Service just called us this week to start teaching use of force law to them. I say this not really to toot my own horn, but so that you guys know that you're hearing from someone who other authoritative sources have accredited. Again, nobody does what I do. All I do is use of force law for more than, 32 years now, 32 years. And how do we serve our community? We do it with educational content. We have a best-selling book. I know many of you mentioned that you already have read my book. Somebody, was it you, sir, said you brought it with you? If you brought the book here and you'd like me to sign it, I'm happy to do that. We have that book. We have DVDs. We have live classes we teach, all focused on defense of yourself, your family, your home, your property. And we have courses on specialized circumstances, too, like defense under riot, looting, arson conditions. The black letter law doesn't change very much, but the context is so much more complicated that how the law is applied to the real world can get complicated. So we have all that educational content. We have what we call our standard membership, where we produce almost every day. We produce video blogs, blog posts, podcasts, doing plain English analysis of real world use events that are occurring in the world every day, that are in the news every day. Those go out to our members. And finally, our actual legal practice, which is a legal consulting practice. So I don't take clients directly. All my clients are other attorneys who are lead counsel for their clients out in the real world. So if any of you were involved in a use of force event, you'd retain a lawyer wherever you were, and if you and your lawyer thought it would be a good idea, you'd talk to me about providing a legal consult to your case. And we do legal consults typically on felony level cases. Most of our cases are aggravated assault with a deadly weapon cases. And they all invariably involve people just like you, like everyone else in this room, who've never been in trouble with the law a day in their lives, got into some kind of confrontation, displayed a gun, never fired it typically, so no one's shot, no one's dead. You displayed a gun for the purpose of changing that other person's behavior. Stop what you're doing, I'm prepared to defend myself. Believe it or not, that checks all the legal boxes for aggravated assault with a deadly weapon, which in most states is good for 10 to 20 years in prison. So the cases I work on are people who've never been in trouble with the law before and are looking at spending much of the rest of their lives in prison if they get convicted on those charges. Of course, we also do murder trials too, as well, manslaughter trials. We do all of that. And I'm proud to say we have almost a perfect record on all these cases. And by perfect record, I mean either we get the charges dismissed or deferred. So if you keep your nose clean for a few months, the charges go away. Or if we go to trial, we get an acquittal at trial. On murder and manslaughter cases, we have a 100% record of either dismissal of charges or acquittals at trial. So that's what we have, our educational content, the books and courses, our member content, the daily plain English analysis of use of force events, and our legal consulting. And as I mentioned, for all of you, this weekend we've put together a special package. I'll mention that to all of you later in a little more detail. So let's talk about the stakes, because people rarely think about what the actual stakes are in self-defense. A lot of people have a sense of bravado about self-defense, right? Well, if I'm ever attacked, I know I'll be able to handle myself. And in fact, you come to courses like this, so you will be able to handle yourself, right? To improve your prospects of being hard to kill. That's why we all come here. But the moment you're engaged in that fight, you've just incurred two risks you were not incurring a moment before. A greater than zero risk of death and a greater than zero risk of going to prison for the rest of your life. Before you were just going about your day. Now you've incurred those risks, because those risks, you can get them as close to zero as possible, but they're never zero, right? You come to a course like this to learn how to be hard to kill. You'll get pretty good with a gun here. I've been here before, it's a great course, but even the best warrior in the world, in all of history, when they got into combat, there was some greater than zero risk they would lose, right? No one's undefeatable. And frankly, you could do everything right legally in self-defense, and you can still find yourself convicted at a trial. So the risk is always greater than zero. The goal is, our goal is realistically to get those risks as close to zero as possible. That's why you're here, for winning the physical fight. That's why you're listening to me now talking about the legal fight. But it's never zero once you're hands-on in the fight. So, of course, we think of self-defense as a physical act. We defend ourselves against some kind of attack. But from a legal perspective, self-defense is a legal defense that your lawyer raises to a criminal charge, some use of force criminal charge. You've killed someone in what you think is self-defense. You're charged with murder or manslaughter. You raise the legal defense of self-defense. You've shot someone and they survived. Maybe it's an attempted murder or an aggravated battery charge. You merely frightened someone with a gun. That's aggravated assault with a deadly weapon, unless you can justify it with the legal defense of self-defense. The good news is self-defense is what we call a perfect defense under the law. It doesn't just mitigate your legal liability. It eliminates your legal liability. What you did was simply not a crime, even if you've killed somebody, if you meet the legal conditions of self-defense. It's literally a license to kill. You're legally licensed to kill another human being if your conduct meets those specific conditions of self-defense. But self-defense as a legal defense is extremely binary. It's like a light switch that's either on or off. Either you meet the conditions and you have zero legal liability, or you fail even one of the conditions and you have 100% legal liability. Self-defense just goes away. So either you qualify or you don't. And it's also important to understand that self-defense is an odd legal defense in the sense that you're not denying it was you. It's not like an alibi defense, right? Where you're saying, hey, it wasn't me. I was someplace else. I had nothing to do with this event. You're saying the opposite of that. You're saying it was you. So it's a defense of what we call confession and avoidance. You're confessing not to a crime, but you're confessing to the underlying conduct. And you're seeking to avoid legal liability through the legal defense of self-defense. So it's the opposite of it wasn't me. You're saying it was me. I did it. I shot that guy. I killed him. But I did it in lawful self-defense. But if the prosecution can defeat your claim of self-defense
What's left of that statement? I shot him in self-defense. Well, if the in self-defense is gone, all that's left is I shot him. So that's just a walk-away conviction for the prosecutor. And the prosecutor knows this. When you show up on his desk, he knows it's going to be a self-defense case. He doesn't have to prove you fired the shot. You're going to concede that you fired the shot. You can't say I didn't shoot him and I did it in self-defense, right? That wouldn't make any sense. So you're going to concede you fired the shot. All he has to do is disprove your claim as self-defense. And then he has an easy conviction. So he doesn't really have to prove the crime because you'll essentially have confessed to the crime if he defeats your claim as self-defense. Now, the good news is you're not required to prove self-defense. Once you raise the legal defense of self-defense, the burden is on the state to disprove self-defense beyond a reasonable doubt. And when they seek to do that, self-defense, as a legal defense, is made up of 5 elements, 5 components, a maximum of 5 components. So that's great news. There's not 500 elements of self-defense. There's not 50. There's only 5 that you have to worry about. And those 5 elements are innocence, imminence, proportionality, avoidance, and reasonableness. And I'll explain each of those quickly. Innocence means you can't have started the fight, basically, right? Which makes sense. You don't want people to start a fight and be able to claim self-defense. Imminence means that what you're defending yourself against is either actually occurring, you're being beaten, or it's immediately about to occur. But it can't be something that happened in the past. It can't be a speculative threat that might happen in the future. It also means that when the threat you're defending yourself against is neutralized, you're not allowed to continue using force after that point. Proportionality basically means you can only use deadly force in self-defense if you're facing a deadly force threat. If you're only facing a non-deadly force threat, you can only use non-deadly force in self-defense. One consequence of that, folks, if you look at the FBI Department of Justice crime statistics, you're 5 times more likely to be facing a non-deadly force threat than a deadly force threat, which means the gun you're carrying around cannot be used for that 5 times more likely scenario. So you'd better have some non-deadly means of defending yourself. Maybe palm pepper spray, they're a sponsor here. Maybe Brazilian Jiu-Jitsu, lots of practitioners here, but something other than the gun. Most of the cases I work on, those aggravated assault with a deadly weapon cases, are law-abiding people who got scared by a threat, went to the gun under circumstances where they were not facing a deadly force threat. So they violated that element of proportionality, and that cost them self-defense, is what the prosecution is claiming in those cases. Avoidance has to do with whether or not you have a legal duty to retreat before you can use deadly force in self-defense. Fortunately, there's only 11 states that are duty to retreat states. The vast majority of states are stand your ground states, so you don't have that legal duty to retreat in an otherwise lawful case of self-defense. And reasonableness means that both you have a subjective, genuine belief in the need to act in self-defense. So that's kind of obvious, right? If even you don't think it's self-defense, why would anybody else? But that subjective belief by itself is not enough. It also must be objectively reasonable, meaning a theoretical, reasonable, and prudent person in the same circumstances would have shared that belief. Another way to put it is your subjective belief in the need to act in self-defense can't be irrational. It can't be speculative. It has to be reasonable in that respect. The catch here is that what controls your legal fate is not whether you thought it was reasonable. It's whether other people who were not there, the police, the prosecution, the judge, the jury, what controls your legal fate is whether they believe what you did was reasonable. Also, you're at the complete mercy of the prosecutor, folks. If you've threatened or used force against another person and that prosecutor wants to argue a criminal charge, there's nothing to stop him from doing that. Not a thing in the world. Forget grand juries, forget any of that. They are not practical barriers to you being prosecuted for a crime. If a DA wants you to go to trial, you're going to go to trial. And the costs are unbelievable. So just an aggravated assault case, you pointed a gun at someone because they were scaring you and you find yourself charged with aggravated assault with a deadly weapon, you can expect your lead attorney to want a retainer of $35,000 to $50,000 for pre-trial work, not for the trial. If you kill someone and you're charged with murder or manslaughter, very common to see defendants go through $200,000 before trial even starts. So that's the kind of money we're talking about here. And of course, you can do all that and still get convicted, right? Just because you're spending a lot of money in your legal defense doesn't mean you don't get convicted. Again, risk of conviction is never zero. It's also important to understand that nobody knows what happened. No one who's judging your legal fate knows what happened with you in any absolute sense, right? They weren't there. The cop wasn't standing next to you when you were attacked. The prosecution wasn't there. The judge wasn't there. The jury certainly wasn't there. So they have no personal knowledge of what happened. All they can do is look at the evidence that's available to them and try to make a reasoned inference about what happened. And the criminal justice system is not about truth. The system knows it cannot achieve truth in an absolute sense. The criminal justice system, first of all, it's a system designed mostly for criminals. And when they say justice, all they mean is a system of applying rules of justice. Innocent people get convicted all the time. And of course, one of the most common things I hear in cases I consult is the client who's law-abiding, never been in trouble before, saying, I can't believe I'm getting prosecuted for self-defense. Well, they believe it was self-defense in their head, but again, that's not what controls their legal fate. At a minimum, I have to tell clients, if we put you in front of the jury, you could be the most innocent client I've ever worked with. There's at least a 10% chance you get convicted. Convicted on a murder charge, folks, means a good probability of life without possibility of early release. So those are the stakes we're talking about. Innocent people get convicted. If innocent people didn't get convicted, we wouldn't need appellate courts, right? But we have appellate courts because trial courts get things wrong. And the jury that's making the ultimate call on your verdict, guilty or not guilty, remember, they weren't there. They're just hearing stories in the courtroom. The prosecution is telling them one story, your defense lawyer is telling them another story, and they're deciding what story they want to believe. Now, some bad news, good news. Bad news is, for all those clients who say, I can't believe I'm getting prosecuted, why would they do this to me? I've never been in trouble before. If a prosecutor is taking you to trial, he's in it to win it. He's not taking you to trial to lose. And prosecutors have conviction rates at trial, 90%. 95%, right? They don't really lose a trial. Now, part of that is because they get to choose the cases they bring to trial. They only bring what they perceive to be easy wins to trial. And that's a huge advantage to us because as much as prosecutors love to win, they hate to lose. Which means for us, if we can present ourselves as if we are hard to convict, we become an unattractive target to prosecution because I see people nodding and smiling. Are you a lawyer by any chance? No, okay. Just wondering. So, prosecutors hate to lose, and that's enormously valuable for us because you can learn how to be hard to convict. That's what we teach at Law of Self-Defense. We're essentially teaching you how to make yourself an unattractive target for prosecution because you look hard to convict. And if you look hard to convict, you're much less likely to be brought to trial. You're much less likely to be charged in the first place. And then you're not spending those hundreds of thousands of dollars on a legal defense. So, a lot of people also seem to have the attitude that, they don't like law. Who likes law, right? I mean, I can't believe all of you are listening to a lawyer talk for a while. But it's complicated, it's obtuse, it's this weird language. Why would anyone know that? If I get in trouble with the law, I'll hire a lawyer, right? That's what you do. If someone sues you, you hire a lawyer. You get injured, you hire a lawyer. You do a closing on your house, you hire a lawyer. That's what lawyers are for, all the legal stuff. And I appreciate the vote of confidence. But the truth is, your lawyer doesn't have a time machine. Your lawyer can't go back and change what you did. Your lawyer is stuck with the facts you give him. And if you give him bad facts because you misunderstood where those legal boundaries were and you stepped over those legal boundaries by an inch, you don't have a viable claim of self-defense. And there's nothing your lawyer can do to change that. On the other hand, if you give your lawyer good facts, you are genuinely hard to convict. Because again, the burden is on the state to disprove your claim of self-defense, and they have to disprove it beyond any reasonable doubt. Now, the advantage for the state, as I mentioned, there's up to 5 elements. The state doesn't have to disprove your claim of self-defense in its entirety because those elements are cumulative. They're required elements. If any one is missing, as a purely technical legal matter, you don't have a claim of self-defense. So each of those 5 elements, from a prosecutor's perspective, is a target of attack for him. If he gets that investigative report from the detectives, what he's looking for is there any one of those 5 elements that I think I can disprove beyond a reasonable doubt? And whether that's true or not is largely going to be a function of your conduct in self-defense. Mostly, it's the defender that makes themselves vulnerable to successful prosecution, successful defeat of their claim of self-defense. So what do we do in this circumstance, right? We want to be hard to kill, we want to be hard to convict as well. And I'll be the first to say, winning the physical fight has to be the top priority. It's more important than the legal fight. If you don't win the physical fight, who gives a shit about the rest? I mean, it's done, right? So you have to win the physical fight. That's why all of you are here this weekend. And how do you do that? How do you prepare for the physical fight? Well, you get tools, right? Whatever your tool of choice. Most of us, it's probably a gun. That's why you're here. Might also be a knife, might be pepper spray, it might be BJJ, whatever. But you get those tools, you get trained in their use, like you're getting trained this weekend. And importantly, folks, after you leave here this weekend, you have to continue to practice with those tools. I'm sure you've all taken courses before. You know, you take a 2-day, 3-day, 4-day shooting course. At the end of those 4 days, you're shooting great. But if you don't pick up that gun again for 6 months, what happens to that skill set? It just goes away. It evaporates. So you have to get tools, training, and practice. And the exact same is true for winning the legal fight, for making yourself hard to convict. You need tools, which is really, from our perspective, is the books, the courses that we teach. You need training, which we think of as our membership, with the almost daily content that we put out to our members. And you need practice. The practice part is our legal consultancy. You're not going to go out and become a lawyer and defend yourself in court. So it's our legal practice that fulfills the practice role here. And that's what makes you hard to kill, what you're doing here this weekend, and what we do at Law Self-Defense is what makes you hard to convict. The good news is it's not hard to make yourself hard to convict, not through legal tricks, but by understanding where the actual legal boundaries are. It's perfectly possible to decisively defend yourself, your family, your property within the legal boundaries. Where people tend to get into trouble is they misunderstand where the legal boundaries are. They genuinely believe they're acting in lawful self-defense, but they're just not. Fortunately, at Law Self-Defense, we can teach you where those legal boundaries are. That's what we do. And it's pretty easy to do. Again, it's only 5 elements to think about. It's not that hard. It's really not rocket science. What is complicated is the real world. The law is pretty straightforward. What's complicated is the real world. Those facts get complicated. Real fights get ambiguous. Threats are ambiguous. They can be hard to understand. That's what we help guide people through, is understanding that complicated world. But we can only help you be hard to convict if you want to be hard to convict. I can't just wave a wand and make all of you hard to convict. There's things you need to do on your part. So you have to ask yourself, do you care if you're easy to convict? A lot of people will just say, hey, better to be judged by 12 than carried by 6. And they'll just let the lawyers take care of it, and they'll just... Folks, you would not believe the number of trials I see where the prosecution, the defense, and the judge, all of them don't understand self-defense law. And that defendant gets convicted because he doesn't know either. He gets convicted out of pure ignorance. And then he has to appeal his conviction and hope to God that he gets some relief on appeal. You know what percentage of convicted defendants get meaningful relief on appeal? Less than 1%. It's about 1/10 of 1%. So I always tell people, if you're thinking like an appeal is like a second bite at the apple, it's not. When you go into a trial, all the legal presumptions are in your favor. You're presumed innocent until you're proven guilty beyond a reasonable doubt. Once you're convicted at trial, you're presumed guilty. All the inferences are in favor of the state, consistent with the conviction. So your appeals are for losers because you lost. You're only appealing if you lost at the trial level. And they're for losers because you have less than a 1% chance of getting any meaningful relief at all. So the question for all of you is, do you want to be hard to convict? Be an unattractive target for prosecution, to be able to decisively and effectively defend yourself, your family, your property, knowing you've reduced your risk of conviction to as close to 0 as possible. Again, the harder you look to convict, the less likely you are to be charged in the first place. Prosecutors have stacks of cases on their desk this high. They have a ton of cases on their desk that are easy convictions, especially stuff like drug possession cases. What's the question? Well, was he in possession of the drugs? That's the conviction. It's easy for him. That's how they get these 95% conviction rates at trial. You want to look like the hardest case to win on his desk. Those are the cases that get dismissed, that get deferred, that don't get taken to trial in the first place. So you could look like this guy. That's what I used to look like before I learned this stuff, walking around with a concealed carry permit at 23 and no idea myself where the legal boundaries were. That's why I got into this area of law. I was terrified. Or you could be hard to convict by learning where the legal boundaries are, or you could be extremely hard to convict if you can take advantage of our legal consultancy, our track record. And it's not just for you, it helps your lawyer too. Again, most lawyers are not properly taught this stuff in law school. Most lawyers don't deal with a lot of what I call good guy cases of self-defense. They may have a lot of bad guy cases of self-defense. But if you talk to lawyers who've been practicing 30 years and you ask them, how many self-defense cases have you done where you genuinely believe that client acted in lawful self-defense? 30-year career, you know what they'll tell you? 3, 4, 5 cases. It's hard to develop expertise in something you only do 5 times over 30 years. So you want to know how to give your lawyer good facts, make your lawyer look like a superhero. And that's the unfair advantage that I want to give to all of you, because I can tell you prosecutors are not used to coming across defendants who are hard to convict. And they don't like it. And it makes them very uncomfortable. Very often, the cases I consult on, I do my consultation, I deliver the defense, a 200-page expert opinion analysis to a reasonable degree of legal certainty, this was lawful self-defense, and they put that on the prosecutor's desk, and the prosecutor's like, screw this, it's too much work. I don't want to do this case. So that's what we want you to be able to do. And again, that strategy I mentioned earlier, learn, maintain, guarantee you have the best effective legal defense. Learn the actual law of self-defense, maintain that knowledge in your mind so it's actionable in the moment of crisis, and guarantee yourself world-class legal expertise. How do we do the learning? Well, that's where our educational stuff comes in. And the bundle I want to share with all of you today for your consideration is essentially our everything bundle. It's everything we have to offer. It's our full-day advanced course, which is 8 hours of self-defense law. That's in DVD format, that's online streamed, and a ticket to our next live course. We teach this course live twice a year. It's our state-specific courses, any 3 states you want. Self-defense law is about 80% across the 50 states, 80% the same. But the 20% difference can mean the difference between conviction and acquittal. So you need to know that too. We give you 3 state courses. That's, again, DVD, online stream format. We have a dedicated course just on defense of property, because defense of property is not 80% the same across the 50 states. It's much more complicated than defense of persons. We have a dedicated course on defense in riot, looting, and arson situations. We have a dedicated course on choosing self-defense insurance programs, how to evaluate those. CCW Safe, USCCA, Armed Citizen Legal Defense Network. They're all different. They all have different strengths and weaknesses. And it's important to know what those are, to understand those. So you're not just sending somebody money every month and you don't even know what you're getting from them or what their commitment to you is. And we have our book, The Law of Self-Defense Principles. Many of you have that already. We give you 3 copies of that book, and we give it to you in audio version and in video version as well. And collectively, all that stuff would be $2,000 if you were just to buy those items separately. As part of this bundle for you, all of you here at S12, we want to give you all of that for free. All of that. It's everything we have to offer in terms of educational content. And then maintaining that knowledge, just like you have to practice after you leave here. The way we help our community maintain this knowledge is by producing new content just about every day. There's the New York City subway choking event, the Kyle Rittenhouse case, the George Zimmerman case. Right now, I just did a show today before I came out here to dinner. There's another unfortunate choking case, a trial happening in Wisconsin right now. One guy did a BJJ choke on another guy, and that other guy died. Unexpectedly died. That's what happened in the New York subway case. I just worked a murder case in Colorado where 2 guys got into a fight. One was clearly a much larger aggressor, and the smaller dude was trained in BJJ, put a cross-collar choke on him, and the other guy died. And our defendant got charged with murder, manslaughter, and criminally reckless homicide. We got him acquitted of all those charges. But it's something I could spend an hour just talking about this. In fact, I just did a show on it. So if you remember, you'll see the show in a couple days when I post it up. But if you practice BJJ, and we're trained and I practice BJJ, I've choked people, I've been choked in the gym, and everything's fine, nobody dies. But in the real world, a lot of the people you might have to defend yourself against, they're physiologically frail. They're on drugs. They're lifelong alcoholics. They have existing cardiovascular disease. They're not healthy people going to a gym. And I think when you put a choke on a healthy person, you get one result. And when you put a choke on someone who's physiologically frail, sometimes those people just turn off. And when you've killed someone, even unintentionally, because you choked them, a prosecutor is going to call that strangulation. They're going to call that murder. or maybe manslaughter. So these are all the kinds of issues we talk about in the content we produce almost every day. And we do that every day so that you're provided this insight, this information, and as a slow drip constantly. So it's easy to consume, it's easy to digest, and when you find yourself in a possible self-defense scenario, in effect, you've trained yourself for that scenario, not 2 years ago, this week. This week you were thinking about that kind of scenario. So you know how to conduct yourself and still be within the legal boundaries. Plus, as a member, our shows are normally done as a live stream every day, and we've got a chat function, and Law Self-Defense members can ask me questions during the chat, whatever, related to the show or not related to the show. So in that sense, I'm a constant live resource you folks can access almost every day. We only do that for our members. Oh, and transcripts. So we produce transcripts of every show. You can download the transcripts for any of our shows. Why is this important? It's important because you may make decisions in self-defense that are based on specialized knowledge and expertise that you've acquired in courses like this. You acted in a certain way in self-defense because of things you've learned in self-defense courses. Well, a jury didn't take that course. A jury's not going to understand why your decision in self-defense was a reasonable one. They don't have your training and experience. Wouldn't it be great if they did have your training and experience? Well, you can do that. You can share your training and experience with them in court. You can bring in an expert witness, use a force expert, to talk to the jury about your training and experience. But you can only do that if you can prove you had that training and experience at the time you acted in self-defense. So you need to be able to document your training and experience. And that's why we do these transcripts. You can download them, you have them on your computer. That's literally hundreds of transcripts that could be presented to a jury in your trial. So they become use of force experts too, just like you are. So a membership would normally, it's not expensive, just our standard membership is only about $10 a month. So that's $120 a year. Now we're at $2,120 for what I've talked about so far. We want to give all of that to you for free. The last part is guaranteeing yourself world-class use of force law expertise. And there I'm talking about me. I'm talking about our Platinum membership. Our Platinum members are the only people eligible for a legal consultation. I don't do outside legal consults anymore at any price. When I did do them, they were a minimum of $10,000, typically much more than that. But we don't do those for outside members. So you have to be a Platinum member in order to be eligible for a consult. If you are a Platinum member, you get that consult for free. There's no $10,000. You don't pay me an additional penny. It's all included as part of your normal monthly Platinum membership. And we're essentially backstopping your lawyer. We're providing your lawyer with that world-class use of force law expertise that I can almost guarantee you your lawyer does not have. Because most lawyers don't have it, and no lawyer does what I do. So again, our retainers, when we took outside consults, used to be a minimum of 10 grand, which is a lot of money. But look at what you're saving. As I said, in many cases, the prosecution just decides to dismiss the charges. So you don't have those hundreds of thousands of pre-trial legal expenses and a multiple of that for a trial. You don't have the risk that you're going to be put in front of a jury and have a 10% chance of conviction. You've reduced your chance of conviction to as close to zero as possible. And again, we only do these now for our Platinum members. So, and for our Platinum members, it doesn't cost anything. And by the way, that's not just for the trial. So you go to trial. Hopefully, you don't have to go to trial. Most of the cases we work on, the charges get dismissed or deferred. But say you go to trial, and the worst happens. You get wrongfully convicted, and now you want to appeal. Guess what? You get my legal consultancy for your appeal. No additional cost. It's all included. What if you're successful on appeal, and they reverse your conviction? You know what happens then? The appellate court doesn't say, oh, you're not guilty. That's not what appellate courts do. They say, yeah, you know what? There was a legal mistake made at trial, so we're going to give you another trial. Congratulations. You get to do the whole trial again. Guess what? I'm still there for your legal consultancy for that second trial. We're with you all the way until there are no further legal options for you, or ideally, we resolve the legal matter in your favor. So, what's the Platinum Protection membership normally cost? Normally, it's $50 a month, so it's $600 a year. For 5 years, that would be $3,000, right? It's a lot of money. By the way, that includes all the benefits of our standard membership, so the daily content we produce is all part of that. So now we're talking about that educational bundle, $2,000 worth of content, 5 years of platinum coverage. Would normally be $3,000, so collectively $5,000. For 25 of you, we've put together 25 of these bundles. We want to offer you all that for 82 cents a day. Now that's 82 cents a day over 5 years, right? So it adds up. But for 25 of you, $5,000 worth of our educational bundle, platinum protection coverage for $1,500, which over 5 years works out to 82 cents a day, saves you $3,500. Plus we'll upgrade you. So those of you who are married, you don't both have to do this. Either one of you can take advantage of this offer, and we'll add your significant other. Doesn't even have to be your wife, your significant other, but only one. I know some of you have crazy lives out there. One significant other gets added for free as part of this offer. So if you're married, it's like half the price for each of you, effectively. Again, all that, the $5,000 worth of content, your spouse, almost $6,000 worth of value now for $1,500, 82 cents a day. But we're only doing 25 of these, so there's about 50 of you here. So it's first come, first served. You want to take advantage of this, you can do it at lawofselfdefense.com/CarryTrainer. By the way, we do have a payment plan option, so it doesn't have to be $1,500 up front. We have a 3 payments and a 6 payments option. So you might want to consider those. And I know some of you already have a bunch of my content. You have a bunch of my courses, you have my books, so maybe you don't need all that. Maybe you have a lot of that already. If all you want is platinum coverage, we have a 1-year, just the platinum offer. So it doesn't include all the educational stuff. And it doesn't include your significant other. It's just 1 year of platinum coverage, which would normally be $600. It's only $400 for, again, 25 of you. So, oh, by the way, that cost reduction from $600 to $400, that $200 savings, that gets locked in permanently. So every year you're saving that $200. It doesn't go up to the regular price the following year. Again, that's at lawofselfdefense.com/CarryTrainer. So we have that 5-year option, 82 cents a day. We have that 1-year option, $400, locks in $200 of savings every year. Those are the 2 things we wanted to share with you for 25 of you. Now, if only, obviously Mickey's recording this, he's going to put it on the CarryTrainer website. If 25 of you don't take advantage of this, when the video goes up, it'll still be available for other people in the CarryTrainer community. So, but there's only those 25 to learn, maintain, guarantee. That's our proven strategy to transform you from easy to convict to hard to convict. And that, folks, is what I had for all of you tonight. Thank you. Before you ask, ma'am, I just want to tell everyone again, I'm going to take questions. I'm happy to take them. I'll stay for an hour if people, especially if anybody has drinks to offer. That'll be fine. But no one should feel obliged to be stuck in your seats while I'm answering questions, okay? I won't consider it impolite. I know it's late. Yes, ma'am.
So on the educational piece, the 5 elements that need self-defense, the thing that stuck out to me was the element of avoidance. You mentioned there was only 11 states that have that element of avoidance. Does your material cover that? Do you give examples in terms of which states have avoidance and which don't?
Yeah, so our full day course lists the 11 states. It actually gets more complicated than that because the 39 states that are stand your ground, there's actually 2 flavors of stand your ground. And there's, I believe now it's 7 states are what I do call hard stand your ground states. In those states, the statutes actually say the jury's not allowed to even consider the possibility of retreat in the case of self-defense. It's just off the table. And if a jury's not allowed to consider an issue, the prosecution's not allowed to argue that issue because it becomes irrelevant, because they can only argue what the jury's allowed to consider. So the jury's legally prohibited from even considering the issue of avoidance. It's off the table. But that's only 7 out of 39 stand your ground states. The other stand your ground states are soft stand your ground states. So there the prosecutors, he's not allowed to say, well, ladies and gentlemen of the jury, this defendant had a legal duty to retreat. There's no legal duty to retreat in any stand your ground state. But what he is allowed to argue is, ladies and gentlemen of the jury, of course there's no legal duty to retreat. We're a proud stand your ground state. We would never impose that kind of legal duty. But you know what? This defendant they could have safely retreated. It's not a legal duty, but they could have, and a reasonable person would have, and therefore their failure to retreat is unreasonable, and reasonableness is the fifth element of self-defense. So it's kind of a backdoor flanking attack on your failure to retreat. What I tell people is, first of all, even the duty to retreat states, the duty only exists if you can do it with complete safety. You're not required to increase your jeopardy to retreat. And I would suggest, no matter what state you're in, if it's genuinely possible for you to retreat from a gunfight in complete safety and not have to kill someone, why wouldn't you do that? I mean, even if you thought you were morally privileged to kill that person, look at the expense and risk just to you. I mean, just think of yourselves. And then you got a spouse, you got kids, you have obligations. You don't want to spend the rest of your life in a cage. And you might have done it all legally right and still get convicted, because innocent people get convicted. So, we ought not be getting into gunfights we don't need to be getting into. So if you could avoid it with complete safety by retreating, I would retreat even in a hard stand your ground state. I'm not literally going to stand my ground if I can safely retreat. From my perspective, if I had to shoot you, you made that happen. I did everything in my power to avoid having to do that. And that includes retreat. If retreat is consistent with my safety and the safety of other people, I have an obligation to protect. So that's my position on duty to retreat. But you can see, so each of these 5 elements I did in like a minute. In our full day course, I spent an hour on each of those, because there's a lot of subtleties in each of those elements that we just don't have the time here to dive into.
Is that included in the education though?
That's included in our, so that bundle includes our full day course, which you get a live ticket to the next one. We do them live twice a year. So there's a lot of Q&A and give and take in the live course. It's done over Zoom. Usually there are a couple hundred people in those. But you also get, we provide it as a 4 DVD set, so it's like 10 hours of course content. And we provided the same course as an online streamed course. So you can just get it on your phone. You have 10 minutes at the dentist office, you're waiting for an appointment, you can pop open any of our intellectual content and just refresh your recollection on it.
You outlined all the criminal law aspects of self-defense. What, in terms of protection of your assets and property from civil liability, should somebody who carries a gun?
So the legal defense of self-defense applies in the civil context too. Now, I focus my efforts on the criminal side because my attitude is you can always make more money. But if you're in a prison for 40 years, the money doesn't really matter anymore. I would suggest to people that given that we live in America, the biggest difference between the criminal and the civil is in criminal court, they have to disprove your claim of self-defense beyond any reasonable doubt. That's a very hard threshold for a prosecutor if you've done things right and made yourself hard to convict. In a civil case, they basically have to overcome your claim of self-defense by 51%. It's a much easier task. Now, there are states that have self-defense immunity provisions where you can get civil immunity from civil suit. But again, you only get the civil immunity if you did it right? A self-defense immunity law doesn't turn a bad shoot into a good shoot. But if you did it right, and your state has the benefit of self-defense immunity, and about half of them do, you can avoid civil suit that way. The other way, of course, is the traditional way of dealing with civil liability, and that's to insure yourself. There's a number of self-defense insurance companies out there that'll cover you for $1 million or whatever their limit is on civil liability. My preferred partner there, and in fact it's on my backpack I was carrying around all day today, and the only one I trust, the only one of these organizations I personally recommend is CCW Safe. I'm personally a member, my wife is personally a member, sponsor of the event. I just did a podcast with those guys a couple days ago when I came through Oklahoma City on my motorcycle. I think the world of that organization. But there are others out there, and they have different characteristics, and maybe the others are a better fit for you in terms of price or what they offer, or whatever. I gotta be honest. But when people ask me for a recommendation, for reasons I'm happy to talk about it while I'm here. I don't mind talking about it. But we could spend an hour talking just about why I don't recommend those other organizations. Is that it? Oh, yes?
Other than moving out of New York State, what do you suggest to people who can't get those?
Well, you can't get those. You can get me. So our platinum coverage applies everywhere. Because my work is essentially done in Colorado, where my law practice is. So New York State can't tell me I can't work in Colorado, so they can't prohibit my platinum program like they do to these other programs. In terms of moving out of state, man, I lived in New York. I moved out of state, so I don't know what to tell you. It is a difficult thing though, because what I found is every time I move states, the new state is good for about 5 years, and then it shits the bed too. So I've been in Colorado 5 years. I'm looking at Nashville now. So maybe I'll move to Nashville. I don't know.
This happened to you, what, 3 times?
Yeah.
Like you started thinking maybe you might be fabulous?
Maybe it's me. Maybe I'm carrying it with me.
They're afraid of you, they're trying to scare you away.
I don't know. It's up to them. Is that it, folks? All right, well, I know it's late. Again, I'm here for the next 3 days. I'm here all the way through Sunday evening. So if anything comes up, any questions, things pop into your mind, I'm completely approachable. Don't hesitate. And with that, I will say good evening to everybody.
Visit our website, CarryTrainer.com, for information about classes held throughout the U.S., CarryTrainer apparel, and upcoming projects. You can also email us at training@CarryTrainer.com for information about setting up your own private course or speaking engagement. Training@CarryTrainer.com or CarryTrainer.com.